name is Rosalind Grant, and I will be bringing you today's Lunch and Learn topic, sponsored by the Family Law section of the State Bar of Georgia. The webinar series schedule had my topic titled Evidence in the Era of Social Media. But since that time, since the schedule was created, I have better titled it Authenticating Social Media Evidence. Or as I'd like to say, tweet me, follow me, Facebook me, but please don't sue me, or Facebook is the devil. As most of you are aware, social media truly is now the new normal. If you do not openly have a social media account, then you might be one of what I call a closet user. But most people really are on social media, whether or not we want to admit that. In fact, recent statistics show that 72% of all internet users are on social media. So it's kind of like everybody's doing it. No longer is social media just the normal for the quote unquote young and the restless. While 89% of users are still between the ages of 18 and 29, as many as 72% of users are between the ages of 30 and 49, and 60% of users are between the ages of 50 and 60. Not exactly what you were expecting, is it? What you won't be surprised about are the biggest social media kids on the block, so to speak, with Facebook coming in at number one still with approximately 1.15 billion users, Google Plus coming in with 1 billion users, and Twitter with 550 million users. Other social media sites not to be forgotten include MySpace, Pinterest, Instagram, LinkedIn, YouTube, Tumblr, Vine, SlideShare, and I'm sure we could continue the list. So today's question is, how can we as practitioners effectively present social media evidence in our courts of law? Now, if you're like me, you may need a refresher on authentication. And just a reminder about the purpose and what the court seeks to do with that process. With respect to evidence, authentication is the act in which the courts decide whether evidence presented is authentic, real, or genuine as to warrant its use in a lawsuit to prove an issue in dispute. Some evidence is self-authenticating, while other evidence must be authenticated. And that's the type of evidence we'll be dealing with today. Again, as a reminder, in respect to matters of authentication, the trial court serves its, as far as I'm concerned, its usual gatekeeping function. If the court discerns enough support in the record to warrant a reasonable juror in determining that the evidence is what it purports to be, then Federal Rule 901A is satisfied and the weight to be given to the evidence is left to a jury. Of course, the proponent bears the burden of introducing evidence sufficient to support the court's finding that the evidence in question is what its proponent claims it to be. Now, easily, at least I can think of some issues with presenting social media evidence. Credibility. In fact, anyone can easily establish a fake account. Most of the social media sites pretty much require that you be over a certain age and have an email address. And you just have to self-state that you're over a certain age and put an accurate date in, most of them to establish or set up an account. Further, if someone does set up or establish a fake account, there's no law against it, which I personally hope is changed in the future. But fragments of information, either crafted under our authority or fabricated by others, are available by easily performing a Google search. Thus, online social networking poses two threats. One, that information may be available because of our own role in creating the content that's put out there. And two, that information may be generated by a third party, whether or not that information is accurate. In this way, social media evidence is very similar to emails or electronic communications. We cannot authenticate, it's important to note that we cannot authenticate a message or a communication solely based on the fact that the message says it is from the alleged author. It's not self-authenticated. We can't just look at it and say, oh yeah, it's from this person and it stands as true. Now let's look at authentication under the Federal Rule of Evidence. Federal Rule of Evidence 901 is titled Authenticating or Identifying Evidence, has two parts, Part A and Part B. In Part A, it kind of sets out the requirement. In general, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. And Section B of the Federal Rule sets out examples about ways in which the court may authenticate the evidence we'd like to present. In pertinent excerpt, two of those examples out of a long list, approximately I think 10, include testimony of a witness with knowledge and distinctive characteristics and the like. In other words, the appearance, contents, substance, internal patterns, or other distinctive characteristics of the item taken together with all of the circumstances. Now, let's consider authentication under the Georgia Rules of Evidence. As most of you know, the Georgia's Evidence Code was updated as recently as last year. Now, prior to the changes made in 2013 to the code, Georgia actually had no comprehensive authentication statute, although this type of evidence was often allowed in court through other means. Now, Georgia has codified OCGA Section 24-9-901, which closely adheres to the federal model, making interpretation and enforcement much easier for us. I personally like the fact that our section is similarly numbered 901, just like the federal section, so it's easy to remember. The new evidence code, our new evidence code, is merely a restatement and reorganization of the law relating to authentication with respect to real evidence and chain of custody issues. Now, let's compare. The Georgia Rule of Evidence under the new OCGA Section 24-9-901, and again, similar pertinent excerpts, provides a Section A and a Section B. And A in its entirety reads, the requirement of authentication or identification as a condition precedent to admissibility shall be satisfied by evidence sufficient to support a finding that the matter in question is what the proponent claims. Now, B, again, gives examples or illustrations as to some of the means in which the court may go about authenticating or identifying information. B reads, by way of illustration only and not by way of limitation, the following are examples of authentication or identification conforming with the requirements of this code section. Again, we see one way listed is the testimony of a witness with knowledge that a matter is what it claims it to be. And subsection 4, another one, says appearance, or another example, appearance, contents, substance, internal patterns, or other distinctive characteristics taken in conjunction with circumstances. Now, let's consider two of the methods I came across in my research on this topic that courts seem to be using in deciding what approach they will take to the authentication of social media evidence. Those two approaches could be coined the high-tech method, or the Maryland approach, and the low-tech method, or the Texas approach. Let's examine the cases that these approaches and methods stem from. The Maryland approach, or the high-tech method, stems from a case, Griffin versus State, 419 Maryland 343, and the full site can be seen once the materials are provided, or in the materials that are provided to you today from the presentation. Now, excuse me, not the full case itself, but the site. Now, with respect to this approach, one of the reasons it's coined a high-tech method is because it involves very technical ways of clearing chain of custody and identification. So they would be like things like ascertaining the IP address of a computer, and also getting information from the social network site itself to say who set up this account, whose name, if it matched the IP address, etc., etc. I feel like most of the cases that I've seen in the research are criminal based because it's a lot easier for criminal prosecutors or the state to solicit or subpoena this information from these social network sites as opposed to civil practitioners like you and I. So the case in point, Griffin versus State, is a criminal case. The facts of that case is that the petitioner appealed convictions related to a shooting death where he contended that the trial judge abused his discretion in admitting several printed pages from petitioner's girlfriend's MySpace profile. The state did not question the girlfriend about the pages allegedly printed from her MySpace page or account, but instead attempted to authenticate the pages as belonging to her through the testimony of the lead investigator in the case. Basically, the trial court relied on the investigator's testimony, who attested that the picture of the girlfriend, her date of birth, and the location on her MySpace page authenticated it as hers. Now, I think that you might already seen the red flag and the issue with this case, and that is the MySpace page was not authenticated or introduced and authenticated through the girlfriend, who actually was the author and creator of the page. So what result do you think under these facts? Well, of course, the trial court found the evidence to be authentic of the MySpace account. The Court of Special Appeals there in Maryland upheld the trial court in finding the evidence to be authentic, but the Court of Appeals did not find the evidence authentic. Instead, it reversed and remanded to the Court of Special Appeals with instructions to reverse and remand for a new trial at the trial court level. And let's look at some of the analysis as to why the court believed that that was appropriate in that case. And again, this is in the Griffin versus State of Maryland case. The court said, "We agree with Griffin that the trial judge abused his discretion in admitting the MySpace evidence pursuant to their local rule, because their 901 evidence rule, because authentication rule, because the picture of Miss Barber, that is the girlfriend, coupled with her birth date and location were not sufficient distinctive characteristics on a MySpace profile to authenticate its printout. Given the prospect that someone other than Miss Barber could have not only have created the site, but also posted the comments, the potential for abuse and manipulation of a social networking site by someone other than its purported creator or user leads to our conclusion that a printout of an image from such a site requires a greater degree of authentication than merely identifying the date of birth of the creator and her visage in a photograph on the site in order to reflect that Miss Barber was its creator and the author of the language." So in this case, they said someone could easily cut and paste or copy a picture of you, and they could easily ascertain or acquire your date of birth. It's on a lot of information we provide to various sources. I also would like to entertain you for a second and read to you one of the statements that was found and introduced from Miss Barber or Griffin's girlfriend's MySpace page. And it said, or it contained the following blurb: "Free Boozy. Just remember, snitches get stitches. You know who you are." So the court said, hey, we need to use that. But then the higher court said it's insufficient. You need to think about it. It needs to be better connections. Now, it's also interesting that the point that the court laid out some suggestions, and this is where we kind of get the rule from this case. For how social media evidence should be more appropriately acquired. First, they said you should ask purported creator if she or he indeed created the profile, and also if they added the posting in question. Second, you should search the computer of the person who allegedly created the profile and posting, and examine the computer's internet history. And third, you should obtain information directly from the social networking website that links the establishment of the profile to the person who allegedly created it, and also links the posting sought to be introduced to the person who initiated it. Again, the court said these things were not mutually exclusive, but that they all had to be done to confirm that the text or the communication is authentic. Now, the court did go on to say, in so doing what it's doing and remanding the case, and saying that the authentication was insufficient in this instance, they should also be heard, and suggest that printouts from social networking sites should never be, they're not saying that they should never be admitted, but possible avenues to explore to properly authenticate a profile or posting printed from a social networking site will in all probability continue to develop as the efforts to eventually utilize information from such sites increases. So they're saying, we're never saying it should be admitted, but these are some of the measures that we believe are necessary to best prove authenticity. And that clearly is, to me as a practitioner, those are very high burdens to prove. Now, I would like to also point out the dissent in this case that I felt like is a good segue into the low-tech method or approach. Now, the dissent read in the Griffin case that it has been said that the purpose of authentication is to filter untrustworthy evidence. However, like many filters that are unable to remove completely all impurities, Rule 901 does not act to disallow any and all evidence that may have impurities, as long as a reasonable juror could conclude that the proffered evidence is what its proponents purport it to be. The evidence should be admitted. So the dissent is saying the question of weight of the evidence should really be given to the juror, as long as a reasonable juror could conclude that it's what it's purported to be. And then once given to the jury should decide the weight of credibility of the evidence. But the majority here is saying, no, this is a preliminary question to be decided by the court or the judge. Again, let's recap. The rule from the Maryland approach, or what we consider to be the high-tech method, is that social media evidence may only be authenticated through testimony admission of the creator, documentation of the internet history hard drive of the purported creator's computer, and information obtained directly from the social networking site. Unless the proponent can demonstrate the authenticity of the social media post to the trial judge using these exacting requirements, the social media evidence will not be admitted, and the jury cannot use it in their factual determination. Now, a special note with respect to this case. This case, again, is still pending a new outcome. So it will be interesting to see if after a new trial, if the question comes up on appeal again, how the court treats it. I would gather that this time the state will introduce the evidence using the actual creator of the MySpace page, which in this case was Miss Barbara or Griffin, the defendant appellate's girlfriend herself, and walk her through or try to acquire some, because this will still be in Maryland, try to actually follow this 1, 2, 3 step process that the court says it's going to require. Now, let's look at the low-tech method, or what will be considered the Texas approach. And that is ascertained by the Tienda versus State case at 358 Southwestern 3rd, 633. The facts in the Tienda case are that the defendant was convicted of murder and pled true to one enhancement count. At issue was whether the Court of Appeals erred in holding that the trial court did not abuse its discretion in finding that MySpace profiles were properly authenticated. So again, in this case, we're looking at MySpace. What result? Well, the trial court, of course, found the evidence authentic. The Court of Appeals upheld the trial court, and the Court of Criminal Appeals of Texas affirmed unanimously. In that court, they looked at a number of different pieces of evidence circumstantial to the MySpace post and said, hey, we're going to allow it in. I think it's also important to note out that the evidence was actually introduced by the, excuse me, the actual creator of the page. And I just wanted to make sure before I said that. Yes. Or actually, it's not the creator of the page, but basically another witness. Actually, two witnesses. So you had a sister of a decedent that the MySpace page was talking about, and then a prosecutor who did offer evidence, subscriber reports, and accompanying affidavits subpoenaed from MySpace. So basically, in that case, the state did take some efforts to get some more of that more quote unquote more solid or legitimate data. Okay, so the rule that comes from the Texas approach, again, is that the proponent can authenticate social media evidence using any type of evidence so long as he or she could demonstrate to the trial judge that a jury could reasonably find that the proffered evidence was authentic. Now let's look at two other cases. Now these are two other national cases, both also criminal. I think I should also point out that all of the cases that I've been scrutinizing and looking at for the most part today are very, very recent cases. We have 2011, 2012, 2013, and even a 2014 case. So this is a steadily evolving area or segment on authentication and evidence that will be very interesting to follow in the years forthcoming. But another national case that I liked, there are two other cases, and both of them actually had to do with Facebook. All right, one of them is Campbell versus State, and that's at 382 Southwestern 3rd, 545, and that involved Facebook messages that were admitted. And in that case, the trial court affirmed the use of the Facebook messages. Another national case is a Parker versus State case. And this is a Delaware case that recently came down in 2014. In fact, it's so recent it came down February of 2014. In Parker, it involved Facebook profile statements that were admitted. The trial court was affirmed, and after comparison of both approaches, it's clear that Delaware clearly favored the Texas approach. So let's look a little bit at Parker v. State in greater detail at Parker v. State case. I like the Parker v. State case because the court goes through an analysis of both approaches, the high and the low-tech approach, or in other words, the Maryland versus the Texas approach. And like I said, decides to clearly favor the Texas approach. But let's look at some of the facts in this case. The defendant appellate, Tiffany Parker, was convicted of second-degree assault. She appealed that conviction, arguing that the Superior Court erred in admitting statements posted on her Facebook profile. Now, I thought this case was interesting because it involved a typical love triangle, 2 women and a man in the middle, and the women apparently run into each other physically and a confrontation ensues, or a physical altercation. Now Parker gets into a fight with Brown, who happens to be pregnant. I would presume maybe over the love interest they are fighting over, but the record is not clear. The Facebook post read as follows, and in my best little scrappy imitation that I can muster. Bet that bitch didn't think I was going to see her ass. Bet she won't inbox me no more. Hashtag caught that bitch. And it goes on to say this girl is crazy. She really got these people thinking that that was some nut shit. First of all, she hit me first. If you really want to put it out there, since you shared, see, I told you, go ahead, inbox me. You inbox me back, still being disrespectful. I told you, say no more. Seen you today. We said our words. You put your hands on me. I hit you back. So it clearly goes into the details of the fight or the discussion. So not only did Parker post as she did, and the state made clear that the Facebook post included Parker's picture, her name, and a timestamp for each entry, stating that they were on the same day as the fight ensued. But the court also noticed that the other individual, Brown, shared the page, and then Brown testified about where she received the comments from. Parker's post, and the court said Parker's post contained very distinctive circumstances or characteristics sufficient to satisfy 901's authentication requirements. Okay, so if I had to point you in a good place to start, I would definitely say the 2 foundational cases that were previously referenced, the Griffin case and the, I'm sorry, not the Campbell, the Griffin case and the Tienda case, excuse me, as well as the Parker case, because it's most recent in time and they do a great job comparing or doing analysis, applying the 2 different approaches. All right, now let's turn and look at a Georgia case. And fortunately, I was able to find a Georgia case on point that is a civil domestic case finally. So in this case, in re LP, it's a juvenile court case. The facts are as follows. Following a bench trial, a juvenile court found LP delinquent for committing the offenses of participation in criminal street gang activity, amongst other offenses. LP contended that the trial court erred in admitting into evidence printouts from a Facebook page that he claims was insufficient to prove that he committed the offense of participation in criminal street gang. What result do you think the court had? Well, in that case, the information was introduced by the officer. What's unique is the officer or the investigator was already familiar with the juvenile delinquent. Using LP's street name, Allie for Real, the Lieutenant Richardson found a user profile on Facebook that used the identity Allie for Real, listed a birth month and a day that matched LP's, and included pictures, multiple pictures of LP. The Facebook page also contained comments about freeing the user's brother, and at the time of the post, the user's brother was incarcerated. The Facebook page contained profile pictures of LP making gang signs and had the phrases A and B and blood killers edited onto some pictures. So the court found that there were enough distinctive characteristics to make the Facebook printouts authentic enough to present to a jury. And it got in. So from that, we've garnered, it looks like the direction the court the Georgia courts may be going in. Again, the result there is that the juvenile court found the Facebook evidence authentic, and the Court of Appeals the Georgia Court of Appeals also found the evidence authentic. The rule from that case, and what I think Georgia will probably likely follow going forward, is that Georgia law favors the admission of any relevant evidence, no matter how slight its probative value, and even evidence of questionable or doubtful relevancy or competency should be admitted, and its weight left to the jurors. Now, what's interesting about this case, it was actually, at least on the juvenile court level for sure, tried prior to the enactment of the new Georgia Evidence Code. Although, again, we had other means and ways in which to allow this evidence in. Okay, so let's look at some of the low-tech conduct that will help authenticate social media evidence. Because, again, this is what I believe Georgia is most likely to use. The first act or conduct is admission. If a party subsequently admits that they wrote the text, that admission will suffice to authenticate the communication, or alternatively, if the party admits some fact that circumstantially supports a finding that the communication was made. So an admission. Corroborative conduct. In the communication, the person said that they would do something, and there is admissible evidence that they subsequently acted in accordance to what they represented. And then finally, the content of the message may support authentication when it relates to matters that only the alleged sender and a few other isolated people would know. So let's recap. Admission. I've gathered that we need to ask the account holder if they have an account, if they created an account, if they use it, if they actually provided the communication that was posted, or if they wrote it. We need to look at their conduct and find ample examples of how their conduct followed their electronic communication, or vice versa, meaning they had some conduct that was mentioned in a post or a communication. And then content, we need to look at distinctive information that only them on their social media site would kind of get or understand, or people that are closely related to the situation or the circumstance at hand would get or know or be privy to. So I think that concludes my time for today. Thank you so much for joining me for today's Lunch and Learn. And I hope you enjoyed your learn as much as you did your lunch. Thank you.